Welcome to the briefing. Today is Wednesday, August 11th. My name is Justin Wickizer. I'm the Director of Legal Operations for the law firm of Smith Freed Eberhard. Thank you for joining us. If you've listened before or watched before, you know that the briefing is our weekly overview of Oregon legal alerts that the firm publishes, as well as Washington legal alerts. But these legal alerts cover new changes in case law and statutory law. So thank you for joining us. I wanted to give you an update for the people that follow along with us and engage in our content and participate in the thought leadership and resources we bring to the claims community. This week, CLM, Council on Litigation Management, is having their annual conference in Atlanta. Jeff Eberhard, who is the editor of our entire, I'll say, content slash legal resource department. He is presenting on COVID-19 and trends and case studies at the CLM annual conference in Atlanta. If you're there, check it out. I don't know if they're going to have a recording of that, but if you're there, please do check it out. I think you'll find it interesting. In addition to that, I wanted to make an announcement and let everyone know that we're also going to be bringing back out our monthly webinars. And the next 6 webinars are going to be focused on our specialty practice areas slash claims specialty areas. So you can look for areas such as dram shop, slip and fall or premise liability. We're going to have a presentation that sounds very, very interesting on the pitfalls and risks associated with drones. So a variety of different topics, and we started working on the outlines on those, and those are going to be, I think, very exciting for people that have an interest in those niche claims areas slash practice areas. So wanted to announce that to you. Here we go. Let's get into the legal alert today. So the title is Indemnification Promises, the Risks of Risk Transfer. So this is from the desk of Melanie Rose. Melanie's a partner in our Portland, Oregon office. Melanie focuses primarily in the commercial, but also personal lines practice areas. So in Oregon, the duty to defend and the duty to indemnify are distinct. Whether an insurer has a duty to defend an action against its insured, it depends on 2 documents. 1, the complaint, and number 2, the insurance policy. So typically, an insurer has a duty to defend an action against its insured if the claim against the insured stated in the complaint could impose liability for conduct covered in the policy. When defending its insured against a claim, an insurer has the right of equitable contribution against co-insurers, regardless of the extra contractual side agreements outside the policy. So in Allianz, the Oregon Supreme Court analyze the application of common law principle of equitable contribution in the context of the transfer of insured liabilities acquired by a successor business. Okay? So that's the background here. Let me give you the claims pointer. This case arose out of an insurance company's action seeking contribution from other insurers for claims and defense costs that it paid on behalf of its insured. In this particular situation, the Oregon Supreme Court considered the question of whether the current insurer of the defendant in the complaint was entitled to common law equitable contribution from previous insurers who covered the insured's predecessor and interest during the time period in which damages were alleged to have accrued. So this is the commercial liability defense, general litigation, professional lines, trucking and transportation, all those practice areas. And the name of this particular ruling was Allianz Global Risk versus Ace Property and Casualty Insurance Company, 367 OR 711. This was on March 25th, 2021. Okay? Here are the facts of this particular ruling. So Daimler-Benz, previously known as Daimler Chrysler, but Daimler-Benz acquired Freightliner, and Freightliner's manufacturing company here in Portland, from Conway Inc. as part of the transaction. Daimler then went ahead and liquidated Freightliner's assets and liabilities into its subsidiary. Daimler Trucks North America, Freightliner, was later dissolved and transferred the majority of its assets and liabilities to Daimler. In this situation, though, Freightliner Daimler expressly assumed and agreed to unconditionally pay and discharge any and all liability and debts of Freightliner. So subsequent to Daimler's acquisition of Freightliner, alleged liabilities related to several environmental remediation proceedings. And those were including claims related to the Portland Harbor Superfund cleanup and to approximately 1,500 asbestos personal injury claims that they were presented with. So the plaintiffs, Allianz Global Risk U.S. Insurance and Allianz Underwriters Insurance Company, had insured Freightliner prior to the acquisition and Daimler in the years following the acquisition. So Daimler had also purchased from Allianz an additional policy to provide coverage for future claims that might be made against Freightliner for its past operations. Okay? So that's critical here. Allianz incurred more than $24 million defending and paying claims based on Freightliner's historical business operations. Allianz filed suit seeking contributions for past and future payments from the other liability insurance companies that insured Freightliner during the course of its business operations. Allianz alleged that it was entitled to common law equitable contribution because each of the defendants was a co-insurer of Freightliner, and Oregon recognizes an insurer's equitable right to contribution. So here's what happened next. The defendant insurance companies declined to defend Daimler or pay claims under the relevant policies or to pay any contribution to Allianz for the amounts that it had paid. They argued that they were not responsible for any payments made by Allianz because the liabilities that they insured for Freightliner and Conway, they were not transferred to Daimler as part of the acquisition and dissolution of Freightliner. So Freightliner's prior parent company, Conway, had entered into side agreements, which the court also called fronting agreements. Essentially, Conway agreed to indemnify the defendant insurers for all claims, defense costs, and other expenses arising out of occurrences subject to the policies. The defendant insurers argued that their fronting agreements with Conway absolved them of the obligation to pay claims on behalf of Freightliner because Conway had contractually absorbed that responsibility. So next time you're in a meeting, talk to somebody on the side, you can look really well read and say, we had a fronting agreement. So here's the law. When determining whether an insurer has a duty to defend a claim, the insurer must consider whether the allegations in the complaint assert a claim covered by the policy. If so, then the insurer has a duty to defend. The duty to indemnify is independent of the duty to defend, and the duties, they're not linked. So when considering whether an insurer has a duty under a policy to defend a lawsuit brought against its insured, the court may look at only the insurance policy and the complaint that the insurer is being asked to defend. This is often called the 8 corners rule because the court is not allowed to consider extrinsic evidence outside the complaint and insurance policy when determining if a duty to defend is present. In interpreting an insurance policy, if a word or phrase is susceptible to differing plausible interpretations and the ambiguity cannot be resolved by considering the context of the wording and the policy as a whole, the ambiguity must be construed in favor of coverage. However, we love however in these legal alerts. Going to bring you another one. So however, while an insurer's obligation to its insured are governed by the insurance policy, among co-insurers, a right to equitable contribution, it does exist, independent of the policy obligations to the insured. This is because Oregon recognizes the equitable doctrine that one who pays money for the benefit of another is entitled to be reimbursed. So the court characterized this doctrine as being guided by the goal of preventing unjust enrichment, okay? And holding that the insurer has an equitable right to contribution from co-insurers, the court found the following reasoning from California's Court of Appeals particularly persuasive. It reads, the right to equitable contribution is predicated on the common sense principle that where multiple insurers or indemnitors share equal contractual liability for the primary indemnification of a loss or the discharge of an obligation, the selection of which indemnitor is to bear the loss should not be left alone often to arbitrary choice of the loss claimant, and no indemnitor should have any incentive to avoid paying a just claim in the hope the claimant will obtain full payment from another co-indemnitor. So that was critical to them. Accordingly, the allegations of a complaint may trigger an insurance obligation to provide a defense that the carrier will have an equitable right of contribution against all other primary carriers on risk for the loss. Here's our analysis. In considering whether the side agreements, or fronting agreements as they're known within the rooms of many well-bound leather books and offices that smell of rich mahogany, between Conway and the defendant insurers eliminate Allianz's ability to seek contributions from the defendant's insurers. The Oregon Supreme Court held that the right of contribution is grounded in principles of equity and is a right that benefits the insurer. Courts considering an inter-insurer contribution claim should be guided by the goal of preventing unjust enrichment to one insurer at the expense of another. So to that end, the court held that an insurance company that issues a policy that covers a particular claim, they cannot simply walk away from an injured third party or a co-insurer seeking contribution. As a result of a private side agreement, fronting agreement, wink wink, rather the court held that the defendant insurers were required to reevaluate the claims presented in their insuring agreements pursuant to the 8 corners rule as mentioned above, and provide coverage as necessary under that analysis. The court acknowledged that the defendant insurers would then have the contractual right under the fronting agreements to seek indemnity for their own expenses from Conway. Nevertheless, though, the defendant insurers could not simply pass through their obligations to Conway. Rather, they needed to fulfill their obligations to defend under the policy and separately seek reimbursement from Conway. So in essence, an insurer who attempts to rely on its side agreements or fronting agreements to obtain indemnity from a third party may have no other option but to pay and chase. I know, bad word, dirty word, but I know many of you claims professionals, this is part of your daily activities. This is an important feature of your job, and that's why we find this legal alert so important and timely for you. The big picture: insurers should be cautious when relying on fronting agreements not contained within an insurance policy for risk transfer. Insurer will be obligated to provide a defense under Oregon's 8 corners rule whenever the allegations of the complaint assert a claim covered by the policy. To the extent the insurer has attempted to transfer risk assumed under the policy back to the insured or to third parties under additional contracts or fronting agreements. Those additional contracts will not alter the insured's duty to defend. Rather, the insurer must continue to provide a defense or share in a defense with co-insurers, and then seek reimbursement separately under the fronting agreement. So you can do that to the extent the indemnifying entity is insolvent and that the risk is borne by the carrier entering the fronting agreement. Thank you very much for joining us today on this important legal alert. Risk transfer, I know it's covered in a lot of different claims specialties. Construction defect often sees this as well. I hope you find it useful and helpful. If you'd like to learn more about it, please reach out to Melanie. She'd be happy to talk to you more about it. I also know Paul Sheely in our firm, our construction defect practice leader, spends the majority of his time dealing with these issues. So thank you again. We appreciate you, your support of the firm, and that is the briefing. Have a great day.